afternoon, Santa Clarita and Canyon Country. You're on the Legal Line with Dennis Kennelly, and it's good to be back with you. It's been some weeks out here, and it's been a pleasure. We've been on about 2 months and really enjoying getting to know the area. Today's show is kind of a potpourri of various legal issues. We'll do a lot on sexual harassment a little later. But right now, one of the things I want to talk about is current events, and some of which may have legal implications, some of which won't. The lead story for all of us is still what's going to happen with health care, and at this point, I don't think anybody knows. I don't think the Republicans know. I think they're in a position where they haven't gotten their act together and gotten a program that they can sell to their own people. They've got a majority in both houses of Congress. They've got a Republican president and yet can't seem to do anything. And the other one is a real puzzler. And that's, what do you do with North Korea? I would hate to be in the White House and try and figure out exactly what the proper cause of action is. It's course of action, not cause. Because normally you can gauge what somebody is looking to accomplish. And from what I've been able to see and figure out so far, all the North Korean premier, president, dictator for life seems to want to accomplish is just to make everybody fear him. And to what end, I don't know. If anybody has some insight into this, I'd be more than welcome to hear about it. As I said, normally you can figure out what somebody's looking for and make a decision whether what they're looking for and what you're looking for can have a community of interest. But in this case, it's a baffler. It really, really is. Speaking of you and the audience, this show is about you. We want to find out what's on your mind. So the number to call in is 661-298-5487. Write it down, 661-298-KHTS. You can follow us on Facebook, on the KHTS Facebook app, and hopefully you can not only hear us, but see us. Of course, I've been told I have a face made for radio, so that may drive down listenership, not drive it up. We've got our usual and customary producer back in the chair, Laura Espinoza-London, who is also part of London Rain, which does our bumper music. And her absence last week was valid because they were in the studio recording finalizing part of their second album, which we're looking forward to releasing sometime a little later in the spring. And we have our more than capable engineer, who also doubled as a producer last week. He's now waving. He's always wanted to be on television. Aaron Delatorre. Aaron has been our engineer from the start and done a really, really great job and taken somebody who's a novice in the talk show business and been really, really helpful. So welcome. As I said, the bumper music you hear at the start of the show and coming in and out of breaks is London Rain. And you can listen to more about London Rain on the website, londonrain.com. It's not spelled the way you think it is. It's Lunden, like the news personality Joan London. And rain is not what falls on your head, but what a queen does or a king does. A king or queen reigns. So it's REIGN. So feel free to check out the website and listen to the music. I think you'll enjoy it as much as I do. A word of caution. I happen to have the pleasure of managing London Rain, so I'm a little biased, but everybody else seems to like it, so we're happy about that. As I said, the phone number, 661-298-5487. One of the things that is puzzling to me in the employment law arena is how the government gets in the way of commerce at times. And this is not only to benefit the employee, but also to benefit the employer. And I'll give you an example. An employee, and this happens with regularity. I get a call on this about once every couple of weeks. The law says that if you work more than 6 hours in a day, you've got to get 2 rest periods, which are 10 minutes each, and you've got to get a minimum lunch hour, unpaid lunch hour or half hour of a half hour. Well, that's fine, but let's say you've got somebody who's got a long commute and would like to squeeze their work time into the period when the commute is not as bad as it normally is. So what they like to do, and this is the most common proposal, they walk into their employer and say, would it be okay if I didn't take a break in the morning, I didn't take my lunch hour, and I didn't take my afternoon break, so I could leave an hour early, if that meets your needs? And the employer says to himself, fine with me, I don't care. All I want you to do is get the job done. And if you can do it within that period, it's fine with me. If I can make life easier for you, make your commute easier, that's fine with me. And guess what, sports fans? You can't do that. You just can't. And similarly, you've got somebody that, with all of these new minimum wage statutes coming up, state law changes, local ordinance, Los Angeles is going to have a $15 an hour minimum wage for workers in qualified companies, and most companies or agencies are going to qualify. But you're a small employer and you'd like to hire a couple of extra employees, but you can't afford $15 an hour. And you've got people that are willing to work for less than $15 an hour. You can't contract around it. Similarly, you've got somebody that wants to be an independent contractor and you want them to be an independent contractor. The reason that workers would want to be independent contractors is many of them have set up their own pension plans, they've got their own health insurance, they've got other clients that they like to work for on an independent contractor basis. But the nature of the particular service that you want them to provide as the employer makes them, by legal definition, employees. Can you and the worker agree that they're going to be independent contractors? The answer, no. Now, why is the government interested in this? Well, they want Social Security. They want unemployment contributions. There are any number of reasons they want it. Now, are you going to get caught? Well, if you're making a deal, for example, with a babysitter, unless you're nominated for a federal post or a federal judgeship, and somebody figures out, hey, let's find out if they paid Social Security for their child care provider, you're likely not going to get caught. But I will tell you, as an employment lawyer, when my children were younger and we had babysitters, we treated them as employees. We paid their Social Security. Now, can I tell you that I was the world's most diligent person in making sure that they got their rest breaks and their meal period? No, because once again, if you look at a meal period, that has to be something where they are free to leave the premises if they wanted to go out and have lunch somewhere and come back within a half hour or 45 minutes or whatever the agreed upon time was. I didn't want to ask. I mean, I guess they could take my child out with them to get the lunch, but then they're still responsible for the child care. So technically, I was probably in violation of the law, like most people that have nannies. So We may be, maybe later in this show, we may have the opportunity to talk to Miles McNamara, who runs an outfit called Comfort Keepers. And he'll talk about where the doctrine of unintended consequences results in the fact that in an effort to make things better for employees in particular industries, guess who just happened to call in? Miles McNamara is with us.
Hey, good morning or good afternoon, barely.
Good noon. Thanks for calling. I was just, your ears must have been burning because I was just talking about you. Miles, why don't you tell us what Comfort Keepers does and give us some of your background?
Sure. Comfort Keepers in-home care. We provide in-home care for seniors or basically any adult who needs a helping hand in the home, be it from injury or illness, but we primarily service seniors. We're not nurses. It's non-medical assistance with all aspects of activities of daily living. So sometimes the senior just needs a helping hand, with their personal care, making sure they're eating properly, getting them to doctor's appointments, help around the house. Reminding them to take their medications, anything that allows them to stay in their own home.
Which is a heck of a lot cheaper than nursing home care.
Absolutely.
And I think most seniors and their families prefer.
Oh, no doubt. A senior wants to stay in their home. It's where they've built the last 30, 40, 50 years of memories. And yeah, absolutely. Staying at home is always the priority first choice of a senior.
Now, I was just talking to the audience about the fact that there's a doctrine of unintended consequences. Our legislature in California is very pro-employee, and I can understand that, quite frankly. But in their zeal to, in their view, do what is right for the employees in the state, they may have regulated a number of employees or prospective employees out of a job because they make it too expensive for anyone to employ people under the rules as they exist. Could you comment on that?
Absolutely. And, we just did one of our lobbying trips to Sacramento with the KHTS road trip, and there's and what you said is exactly true, Dennis. Sometimes that sword cuts both ways, and sometimes you'll legislate employees out of work, and you'll also legislate affordable home care away from our seniors. And one of the things that's in the forefront right now is when a senior really needs an extensive amount of help in the home, they have what they call live-in. And so there's a bill actually being worked on right now through Senator Stone, SB 1344, which basically would allow a caregiver to sleep in the home and have that time deducted from their work hours should there be a written agreement between the employee and the employer. But if they're there for basically an emergency, so if the senior does need help at night and that caregiver is awakened, well, then that will be hours work and they will be paid. A lot of times at an overtime rate because of the different overtime parameters for home care. But because home care is private pay, if you have long-term care insurance, great, but more often than not, it's out-of-pocket expense. Medicare, Medi-Cal, private insurance does not pay for home care. So if we make the care too unaffordable, the seniors won't be able to stay in their own home and have that. And there's also caregivers who love that live-in role, and it basically omits that job description, so there won't be a job for that caregiver. So, and Senator Stone's office is very open to what we call the spirit of compromise, and they're talking, because if the caregiver agrees and has that written agreement and agrees to have their sleep time deducted, but they're paid if they are awakened for an emergency. So they're right now in the talks to hopefully, common sense and logic will win out the day where it'll make the care affordable for the senior, it'll create jobs for the caregiver, and as long as it's fair for both. So there comes the spirit of compromise. Let's find middle ground that creates jobs for the caregiver and they're being paid and treated fairly, and it keeps the cost for the seniors who need around-the-clock care affordable to a degree, because it's still very costly, unfortunately. But at least it brings the cost down.
Now, right now, any time that the caregiver is on the premises, whether asleep or not, they're getting paid, aren't they?
Right, and as you know better than I, Dennis, there's that what do they call it, the employer control. Even though if they are sleeping and they can deduct their time, bottom line is they can't leave the premise, so they are still technically under employer control. So again, that's where they're discussing right now is to find that middle ground where if the caregiver does get their 8 hours sleep, then that's deducted from work time. But if they are awakened, they're paid for that time worked. And if they don't at least get 5 hours of uninterrupted, then they get their entire 8 hours. So I mean, there's a lot of parameters there that make sure that the caregiver is being treated fairly, and that the senior knows that they're sleeping there in case of an emergency. But if you do have to wake them up and the circumstances require them to be awakened, then they will be billed for that. But then you also start to reevaluate the client's ability to have that care at a costly level if their care needs become too extensive.
Exactly, because what you're probably talking about with the overtime laws as they are now, you're probably talking about the current situation being double currently what they would pay under what the caregiver, not the caregiver would get, and
correct.
what the patient payee would have to provide in terms of money, and that can
Correct.
make a heck of a lot of difference, especially on self-pay.
Well, and there's been a lot of changes in the last few years. There for the domestic home work employee, there was Wage Order 15, and all this was sort of sub-articles of Wage Order 15 that sort of treated the home care industry specifically different when it came to overtime and hours worked, and kept that cost down. But I think there was some movement that was needed in fairness to the employee. But again, looking for that middle ground where the employee is happy and has that agreement that they understand how and why they're being paid a certain rate, and it also controls the costs for the seniors and allows them to budget and see if home care is the right answer for them.
Understood. Miles, as a fellow host here on KHTS, you'll agree we've got to take a break right now, and on the other side of the hour, you'll be back on the legal line with Miles McNamara and my name, Dennis Kennelly. Look forward to it.